We're just going to begin now. For those of you who don't know me by now, my name is Jessica, and today we have with us Junyan. Junyan is the Executive Director of Singapore Mediation Centre. So Singapore Mediation Centre is the main service provider in Singapore and not in the oldest as well. So without further ado, Junyan's going to be sharing with us.
Business relationships are hard. This is why I choose mediation for my business disputes. Compared to going to court or arbitration, mediation saves me time and money. Mediation is confidential, so my disputes don't end up on the news or social media. I get to choose who the neutral in my mediation is. Mediation helps to preserve my business relationships and allows for creative solutions which can't be found in court or arbitration. Don't let business disputes frustrate you. Try mediation today.
Thanks, Jessica. Hi, everyone. Hi, everyone. Welcome to this little, fireside chat. What would you call this? A little networking session. I was just chatting with Jessica before this, and it's quite fantastic to hear that there's so many people from around the world that have signed up to be part of this competition, even though it involves waking up at really crazy hours and trying to log in to participate. But the response has been very positive, and I'm very glad, because it's a good sign that mediation is something that people are interested in, and for the students who are just looking to see where this can lead them in their career path. I hope that this journey in this competition will be another milestone for you in your consideration for mediation as a career. So for myself, I run the Singapore Mediation Centre, where the vast majority of our work concerns domestic mediation, which is cases involving two parties that are from Singapore. We do have cross-border cases as well, but those are complicated to try to categorize, because what is a cross-border case? We've got Singapore companies that are disputing over something that occurred overseas, or we have two companies that are headquartered in Singapore, but they actually are foreign companies, and the dispute is run out of Singapore. So is that a domestic dispute? So we have a lot of these interesting things. So I think after a while, we stopped trying to classify things, and we just say, look, okay, if you have a dispute, what is the nature of the dispute? And that's the more useful categorization. So we have different types of disputes. We have the majority of them would be commercial disputes, which means business disputes between companies. But we also have disputes of certain kinds of specific sectors. We have medical disputes, say a patient isn't satisfied with the way they were treated in a hospital, or a doctor's recommendations and prescriptions. Or we have education disputes, where students who've signed up for a course felt that they weren't getting their money's worth, or the school closed down suddenly and they want a refund. And we have family disputes, which are a very messy area, because it involves divorcing couples. And they besides the divorce itself, you have to talk about custody of the children, you have to talk about visitation rights, maintenance, division of matrimonial assets. So all these things, mediation is increasingly being used for this, because it is far and away the most appropriate way to resolve a divorce, the issues relating to a divorce. And certainly it's superior to a case where a judge sits at a distance and says, okay, I think you should be allowed to see your son 3 days a week. On what basis? How does a judge come to that conclusion? How will he know what works best for the family? So mediations where people talk it over, and we really feel that family mediation is something that's going to continue to grow larger and larger. So here in SMC, we fulfill many functions in Singapore. we don't just administer mediations and appoint mediators for cases. We also do training. So for us, it's a case of accrediting mediators so that they are able to do commercial mediation and to a lesser extent, some of the specialized areas of family, of intellectual property, and so on. So this is really what SMC does. But what is part of our broader ambit is we really want to promote mediation as a form of dispute resolution. And I think that's one of the big challenges. Mediation is the poor cousin of the other types of dispute resolutions mechanisms that are being used for commercial disputes, particularly. Mostly people still use arbitration and they go to court for litigation. A lot of times it's because the lawyers are the most familiar with that. A lot of times because there's the impression in people's minds that that's the best way to get an outcome when the other side is not cooperating. But actually, we realize that a lot of people don't know about mediation, or they don't know enough about mediation. They have an impression of what it is. They have heard of the term, but in their minds, it's a totally different version of mediation. Some people think it's like arbitration with a bit more flexible rules. Some people think it's just negotiation with somebody in the middle as a referee to make sure that they don't kill each other. I think all of that really misrepresents what mediation is about and what a good mediator can bring to the table. So we really find that a large part of our work is trying to educate people about mediation, to help people understand that there are very few situations that mediation is not suitable for a dispute. Very few. I would say that things like, say, there's a criminal offense that's been disclosed. So I don't know, I don't think that you should end up trying to discuss how to deal with a criminal offense. And when there's a point of law involved, I think that's one of those areas where you have to go to court because you need clarity. You need a judge to pronounce, okay, so this is the legal position based on the statute, and that gives clarity and certainty and precedent for people to say, okay, in future, our business dealings will be oriented in that direction because now we know what the law says about this. So you need clarity and you go to court. But apart from that, just about every other situation is something that mediation is really the best way to resolve the dispute. Because if it arises out of a relationship, say a contractual relationship, at one point in time when these two parties entered into a contractual relationship, there was the desire to work together, to do business together, to achieve some kind of win-win outcome for each other. And somewhere along the way, something went wrong. Someone didn't do something, didn't fulfill their obligations, or something went wrong that was neither party's fault, but now nobody wants to take the burden of the loss, and they're trying to pass the loss to each other and so on. So there are all these things that can happen in the business relationship, but at one point in time, they were interested in working together. And mediation recognizes that dynamic. Mediation basically says, look, you guys at some point in time managed to agree on something. That's why you even have a contract in the first place that you both signed. Are we able to dial back, everything that's happened and try to get to a point where you can come to some kind of agreement now after everything that's happened, and mediation strives to try to help people put aside animosity and bitterness that may have arisen along the way. People accusing each other. Oh, you didn't do this. You betrayed me. You said this. You promised this. You were nasty here. You didn't answer my phone calls. Trying to get people to sort of put aside that emotional side of things, and also to get people to focus on, hey, I know you feel that this is a matter of principle, that you must get this outcome. They were the ones in the wrong. You're the one who's right. So you want to punish them. You want to show them that they can't get away with it. But is that practical? Is it worth it for you to try to pursue that for this notional justice that you're going to get? Or is it better to just say, look, okay, fine, I will settle for an apology and half of what I'm asking for. If you agree to that, I will sign off on it and we can close this once and for all. It's an attempt to try to get people to be realistic about what their options are, to recognize that you don't always get what you want. And even going to court, no matter what your lawyer tells you, no matter what happened in previous cases, you could still lose the case that you're in. So there's a certain amount of uncertainty. And of course, the biggest problem with going to court and even for arbitration to some extent is that the process is adversarial. It is where both sides try to win the case by tearing down the other person's case, by showing that the other person, has a weak case, has, I don't know, falsified the evidence, or has made up stories that are not true and can't be backed up by evidence, or simply has been at fault throughout, and so the whole nature of the process is that you may even win the case, but you have damaged the relationship with the other side so badly that you can never work together again. You cannot, resurrect that point in time when you were working together closely. And you may think, well, that's not significant because, after all that they've done, I'm not sure I want to work with them anymore, so it's fine, I don't think that's always the case, because in some industries, the market's very small. There are only a few big players. You can't afford to alienate this other side, because then your options are very, very small. If you don't want to work with them, there's almost no one left. And at the point when you decided to go into business with the other side, when you decided to sign a contract, there must have been something that made you decide this party is the best business partner that I can have. This person's services are exactly what I need. This person's products will fulfill my order exactly. And now that's no longer an option. I can't use this person's services. I can't use this person's product because I won the case, but we're not on talking terms anymore. It was so terrible. Our lawyers really just ripped into the witnesses during the court case, and now nobody wants to even be in the same room as each other. I don't know, in the long run, is that productive? Is that a good business outcome? I'm unconvinced, because there are many times when a single dispute is much smaller than the longer term business relationship that is worth preserving. And in fact, you may want to just give a bit more in a negotiation or in a mediation in order to preserve that goodwill, so that in the future, you can continue to work together with what you have already decided is the best partner for your business. So these are things which I think people aren't clear enough about in terms of mediation. People haven't really tried mediation and seen how effective it is. To some people, look, if there's no compulsion involved, if there's no judge or arbitrator to come and scold the other side and to make a ruling when they are being difficult, then there's no point, because I've sent so many emails, I've tried to call the other side, we've even had a couple of face-to-face meetings, and all the time it failed. It has never achieved anything meaningful. And so why bother? Why put us in a room again with a third party? It's not going to change anything. I think that's a fair sentiment. It is an easy thing to assume because you've never actually seen what a mediator does. But if you look at the really good mediators, they actually do what is almost like magic, where they can achieve settlements in situations where the parties, both sides, were convinced that it was not possible. And some of the things that really make mediation very powerful is that the human psychology involved in mediation is that just a neutral in the room can change the dynamic of a conversation. That you can say, well, I've argued with this person ad nauseum and they will never listen. I don't see what you can do. Well, sometimes having a neutral in the room, especially if the neutral is a respected person, a very senior member of the industry you come from, or a very recognized and trusted neutral, a very senior lawyer or a former judge, that person's presence in the room sometimes makes everyone a little bit better behaved. You don't attack each other with insults and accusations. You sort of don't cut each other off every time someone tries to say something, but you hold your peace and the other side gets a chance to tell their story. And that alone, you'll be surprised, can make a lot of difference. The fact that one side gets to tell their story fully, all the way to the end, could completely change your perspective of it when you realize that, oh, wow, there are very important aspects of how the other side sees the dispute that I never realized. And the reason why I never realized it was because I never let them finish their sentence. So I never let them complete a paragraph without me, jumping in and saying that you're lying, you're wrong. But because the mediator sort of persuaded me to shut up and listen. I gained some new insight. And likewise, the other side had to do the same. They had to allow me to tell my whole story, and they began to realize that the way I saw the dispute was very different. And that made everybody sort of say, okay, hang on, is that why we were fighting? Actually, that doesn't make any sense. We both have a completely different idea, and it's really a misunderstanding more than anything else. So this is something that we began to see more and more in mediations, where the skillful mediator takes some time to try to figure out why there's an impasse. And it comes in different forms. It can be the party's valuation of something is too far apart. This person says, you broke this and I want $100. And this other person says, no, it's only worth 10. So why should I give you $100 for a $10 item? So there's no like emotional sort of baggage inside, but it's just that their valuation of it is so far apart and they can't agree. Or it could be, they just couldn't figure out any solution. One party says, you owe me $100. The other side says, I have no problem with that. I agree that I owe you $100, but I can't pay. I don't have the money. And the other side says, well, I don't care. You got to go and find the money, go borrow, go do something, go sell something, but pay me, right? So there's an impasse because one side says, I can't fulfill what you want me to fulfill, even though I don't dispute that I should do it, right? And then the solution actually comes in a different form. It's about problem solving. It's about putting options on the table. Say, okay, let's say you can't get the $100. What else are you prepared to accept? Maybe he doesn't have money, but maybe he's got some other collaterals that you are willing to accept. Maybe take his cow, take his his pig, his sheep, or you come and use his hotel for free for a month. I don't know. I mean, that part again of mediation where parties are encouraged to talk about what they're prepared to accept and what they're prepared to put on the table suddenly opens up the conversation where, well, okay, I realize that it's not such a difficult outcome that we were imagining now, because there's some pretty interesting things that you have put on the table, which I could not have known about that you would have put on the table. Like you offer to do some service for me from a related company. I didn't even know you had such a related company. I didn't even know your company could do this service, but that service is actually quite interesting and useful for me. I might be able to accept that in return for the thing that I demanded. So mediation involves problem solving at some point. Mediation also involves things like getting parties to sort of realize that their demands were unreasonable, that they couldn't have gotten what they're demanding, even if they'd gone to court, to say, look, I'm from the industry, I've been in this industry for 40 years, nobody gets what you're asking for. And if you try to get it, you won't get it. So why are you paying money to sue somebody for an outcome that you will never get anyway, right? So that's reality testing, and one of the things that a skillful mediator does well. So I think this is something which we in SMC, are working with other mediation bodies in Singapore, like CME, like SIMC, like CDRC, to try to create that awareness, to tell people, hey, give it a chance. You'll be surprised at some of the most impossible cases that get resolved. And some of the cases that get resolved in the most interesting manner. I actually have a story which I love to tell. It comes from one of our mediators who actually mediates in the state courts. And he shared this story, which I love, in one of his training sessions. He shared about how there was a case that came before him, and it was a typical case. One party owed money to the other party and demanded it back. So before the mediation began, he met with the lawyers from both sides and asked, what are your clients prepared to give and to accept in order to have a settlement in this case? And interestingly enough, the lawyer for the claimant actually said, my client is prepared to drop the case and even pay the legal fees of the other side if the other side apologizes to my client in front of the mediator. And that was such a strange request. It's like, you not only drop the case, but you are prepared to even pay the lawyer's fees for the other side. That's a very weird arrangement. So the other side was agreeable to that. So he said, okay, I'll go and bring this back to my client and I'll let him know and we'll see what happens. So when the mediation began, and I have to say this is a state court mediation. So the person who's mediating is actually a district judge. So this is in a courtroom. The parties come in, their lawyers come in, and the judge asks, okay, so what's the decision of your clients? And the respondent's lawyer said, my client's agreeable to it. He will give the apology. So he goes, and so this guy comes forward and he just hangs his head down and he starts to mumble, mumble to the other side, I'm sorry, whatever. The claimant walks over to the respondent and smacks him across the face in the middle of the courtroom in front of the judge. And so the judge is like, whoa, what? Do I need to call security? What's going on, right? And the claimant just unloads on the respondent. He just scolds him and scolds him and scolds him and scolds him. So the judge mediator sort of senses that there's something here that's a bit unusual, and he sort of lets it go for a while he listens and tries to figure out what's going on. And he realizes that these two are brothers. And the claimant is the older brother who had lent money to the younger brother. And the story that came out was the older brother actually inherited the family business when the parents passed away. And he took it on himself to try to take care of the younger brother. And he felt that the younger brother was not taking his own life seriously. So in the end, he offered to lend the younger brother a sum of money so that the younger brother could start his own business and try to do something meaningful with his life. And of course, he didn't. And he used that money, he wasted it. And now, the older brother was very angry and felt like there's no way I can reach him. I can't get through to him. I need to punish him so that he wakes up his idea. He realizes that he's just messing around and making our parents ashamed if he was still alive today. So he decided to sue the younger brother for the debt, but he really didn't want the money. He was just hoping to send a message across. So that's why he asked for the apology. And in the end, the younger brother agreed to apologize, and the debt was forgiven and the legal fees were covered by the older brother. But it was such an unusual outcome. It was such an unusual demand, such an unusual solution that you will never see something like this in a court case. You'll never see parties going to court and the lawyer says, Your Honor, I'm pleading that my client wants an apology. And the judge will say, okay, I order you apologize, case dismissed. Sorry, it's not one of the remedies the court gives. So it's very interesting that the mediation, as a mechanism, really allows anything under the sun. It allows you to do just about whatever you feel is appropriate and effective in coming to a settlement. So I think this is something which I hope that more and more parties, especially like I mentioned, in domestic disputes, family cases, or even community mediation between neighbors, people who know each other and they're not happy with the behavior, whether they'll give mediation a try and see that actually a lot of the trouble that they could have gone through to hire a lawyer and to serve a writ on the other side to go to court, all that is unnecessary expense, unnecessary effort, unnecessary aggravation, and you don't even get a good outcome. So hopefully after they've tried mediation, they've done it a few times and they realize that, wow, okay, it's not going to solve every problem. There are some cases that just don't end in a settlement, but at least I give it a try. At least I do this as a first resort, and only if it fails, then we think about going to court or arbitration or something else along those lines. Which is why there are clauses in contracts which are called met up, which means that when parties have a dispute, they agree that they will go for mediation first, and only if the mediation fails, then they would activate the arbitration after that. And I think that's going to be something that you'll see increasingly in business contracts, or another version called met up, where you trigger the arbitration first to get people to take you seriously, and then you adjourn the arbitration to go for a mediation session. And if it works out, it ends there. But if it doesn't, then it goes back to the arbitration and you finish it there with a judgment, with an arbitral award. So I actually think that mediation is a really is the best kept secret in the dispute resolution world, and we're working hard to change that. We are trying to create awareness, and I think the Singapore Convention is a really important step forward in creating that awareness. But I think the future for mediation is going to be bright. You're going to see more and more people use it, more and more people putting it in their contracts, more and more people asking for it, and more people responding by wanting to become mediators or mediation advocates, where they actually say to people that I'm a lawyer, but I specialize in helping you in mediations, to prepare for mediation, and throughout the mediation to help you secure a settlement that's good. And then in the end, I will draft for you a very good settlement agreement. Some people will begin to specialize in that way. And I think that's only going to be positive for the industry. That's my spiel at the start. And I'm looking forward to any questions you have, anything you want to ask.
Thank you for the really informative presentation, Junyan. So for those of you who have questions for Junyan, please feel free to put them in the chat. If you are shy, if you're not feeling shy, you can unmute yourselves and speak to Junyan directly.
Hi, can you hear me?
Hi,
yes.
Samuel, is that Samuel?
Yes. Hi, sir.
Hi, yes.
Question, because participating in competition, sometimes it feels like everything is a bit theoretical. The hypothetical is just a hypothetical. Could you tell us about some of your more memorable mediation experiences or moments?
Well, like I said, the one I mentioned earlier was one interesting example. We've had cases where parties went in with like a debt that they were demanding to be repaid, and the other side said, I can't pay this, I don't have the money for it. And it seemed like an impasse. The other side says, okay, if you can't pay, I'm just going to sue you and make you bankrupt until I get my money back. And then eventually, as they talked, what the side that wanted money said, look, I don't really believe that you're trying very hard to raise money. Are you borrowing money? Are you doing something to repay the debt? And so the respondent said, look, I've been trying to sell this piece of equipment that I don't need and I don't use, but there's no real market for this. No one seems to want to buy it. If I could sell this, I could raise enough money to pay you back. And the claimant was like, wait, this piece of equipment, are you saying that you have this and what's the condition of it and so on? So as it turns out, the piece of equipment wasn't really valuable in the country of the respondent, and therefore the respondent had trouble selling it. But it's actually quite valuable, and there's a demand for it in the country of the claimant. So in the end, the settlement agreement was that the respondent agreed, instead of trying to sell it and raise money and then pay the debt, they would actually transfer the ownership of this piece of equipment over to the claimant, who would then sell it in their home country, and then they would call it square. They will use that to realize the debt. And that ended up being an amicable settlement, which would not have been possible in any other setting because it's not the subject matter of the dispute. No one in a court case would have demanded a list of all your other assets so that I can cherry pick the ones I want. But in the course of the mediation, it came out in the conversation and it became an option that was put on the table. And the other side said, hey, I'm okay with that. I would take that and then we'll close this case. So it's another example where there's some pretty amazing stories that have come out of it. There was a case where the parties agreed that rectification needed to be done for a construction project where something wasn't done properly or there were some defects and rectification needed to be done. But they could not agree on how to determine that the rectification had been properly completed, because one side would say, oh, I've done a good job. And the other side says, no, it's sloppy, it's unfinished. I want you to do it again until it's satisfactory. So there was a disagreement as to how to determine when the rectification was satisfactory. So finally, he said, well, let's appoint an expert, a recognized expert in the industry who will then verify that the work has been properly done. And they said, okay, that looks great. So who is this expert? And there were three parties in this mediation. All three put a name on the table, said, I know this person, I know this person, I know this person, can verify. And of course, everyone's like, well, I don't want to use your person because I'm not sure that he would be fair. He might be biased towards you. And likewise, the other side says, well, I won't use yours either. So it became another source of impasse. The expert itself became an impasse. So finally, the mediator, made a suggestion. Look, are you okay if we just draw lots? And whichever lot we draw, that's the one that we're going to use. And they all thought, well, okay, actually, that's not a terrible idea because these three people are actually credible in the industry. It's just that I don't know whether they are credible, but they also know you personally, and there may be something here that I'm worried about. So they decided, well, it's a risk we all equally take. So they wrote the three experts' names on 3 pieces of paper, and then they put it into like a cup. And they told the mediator, okay, mediator, can you draw? Whoever you draw, that's the one we're using. And the mediator's like, what? Okay, I didn't sign up for this, but anyway. So he drew something out, and that name became the name that they all agreed, okay, so this person will be the one that we appoint to verify that once the person says the work is done, that's the end of the matter. So it's again a very interesting solution, drawing lots. Where would you ever find that in a court case? Where would you find that in arbitration? So there are all these very interesting stories, and there are many more, but I don't want to like dominate this whole Q&A just with war stories. But I hope you realize that the reality is mediation is actually very interesting, and the sky's the limit. A good mediator is actually a very creative one who can help the parties think outside the box and find new solutions.
Thank you, Junyan. So it's really interesting how you say, like, only in mediation we get to see people draw lots, like do something different. It's not like in courts. So like and then earlier on in your presentation, you also mentioned something about like how mediation can be used to settle anything under the sun, which is really very inspiring, because like you don't get this in any of the other ADR mechanisms. That's the thing about mediation, it's flexibility. So I think like I speak for maybe some of the participants in this year's batch where a couple of them actually have like criminal interest. And one of the other things that's like a hot topic is that how can they like sort of like marry their criminal interest with mediation? Because we see a lot of mediation in like commercial cases, contract cases, that sort of thing. What are your thoughts?
So that's an interesting question. Criminal cases are tricky because there's actually 2 problems when a person commits a crime. One is that you have you have basically created an offense against an individual, a victim, but you've also created an offense against the state, because as a country, as a society, there are certain things which are frowned upon, and therefore we have made it a crime. So when you do something that's a crime, it means that this is a no-no, and there are consequences when you do it. So when you look at these 2 elements, even if you can mediate away the consequences of the offense towards the victim, which happens, like say you compensate someone, or you do some restitution for the harm done, there's still that lingering question of what about the response from the state? Can you mediate away the penalties that the state imposes in order to deter other people from committing that crime? And my answer is you probably can't, because it would not be in the interest of the state to allow people to say, well, okay, you can get away with this if you do this. If there is a way that you could so-called compound the offense by paying like a fine, that would already be captured in the legislation. You will have people who say, okay, you did this wrong, you were speeding, so you pay a fine. You're parking illegally, you pay a fine, right? So in those cases, there's all that, and apart from that, I don't know whether public policy will allow you to say, I committed this offense and I want to mediate. I want someone to stand between me and the government and to sort of help the government understand that I was innocent or I didn't mean it, right? So criminal matters are difficult. I would say that at best mediation can be used for when there's a victim and there's a case of you wanting to make some kind of restitution to the victim, and the victim is not willing to see you, the victim is not willing to accept the restitution. A mediator may have a role to play in trying to persuade the person to say, look, this person is genuinely remorseful. It was something done in a moment of anger. The person was reckless, but now genuinely remorseful and wants to make it up. Are you prepared to at least accept some of it? And whether that outcome of that restitution process has any impact on the person's sentence or penalties from the state, that remains to be seen. I think, again, we are not in a position to comment. That's a decision of the state authorities. But so that's why I say I think it's complicated, because in most other situations, the outcome can be determined by the parties, because I either have a dispute with you and what I'm prepared to accept, what you're prepared to accept, it can end there. But when there's a state party involved because of a crime, now, not sure you can mediate that away.
Definitely. Well, hypothetically speaking, there are different sort of like goals when it comes to imposing punishment on criminals. And mostly what most societies have actually done in place is to put something to deter. So we have in place like a punishment to deter them. But what about like say restorative justice, where we think that like, oh, they are actually how should I say they criminalize because they feel that they have no other option.
Sure.
So in that sense, we should be helping them because there's something wrong with them. It's
Sure.
not we should punish them just because they are wrong.
No, that's a fair point. I mean, we're kind of moving a little bit out of mediation now into a bit of like criminal law. There are various objectives in criminal law. Like when you incarcerate someone, it's not necessarily just for deterrence or for retribution. It can be for rehabilitation. It can be simply just to keep someone away from society. So there are various reasons why certain things are done, and I think that already has to be taken into account at the level where the state, I guess in the sense of the Attorney General's chambers and the prosecution side, they have to take that into account when they are recommending some kind of sort of a charge or a sentence. And within that space, there may be some opportunity to speak to the person to say, look, if you are prepared to accept that this was wrong and acknowledge it, and to do some community service, you can have a lower sentence and stuff like that. In this space, then at least it helps to bring a person a bit closer to restoring them. I think that's kind of already built into the process. And even if you didn't have it and you wanted to introduce that, I'm not sure you would describe that as mediation in the sense that we understand, because it's kind of like, I want someone to mediate between me and the prosecutor. I don't really think that's how you would classify mediation, although the process may look similar in some ways. It may be more, I guess a criminal lawyer would call it plea bargaining, and sort of basically saying, look, my client is really remorseful. He's not one of those unrepentant, no hope cases, and you really must, really make an example out of him. He's not that sort. So, he's already demonstrated in the aftermath of the crime, a lot of steps towards trying to redeem himself. So maybe that could be taken into account in the charge, in the sentence, and even going forward, whether that can also be taken into account for future early release and so on, right? So all that, I think, is part of the system, but maybe not quite mediation as we know it.
Very interesting. Well, but then again, like, how like public policy is always influenced by sort of like society's thoughts, like society in that particular country as well. But that's a conversation for another day. So we do have a question from Brian now. Brian says, thank you very much for the discussion of your experiences and examples of creative outcomes that can be brokered in mediation. Do you think that the Singapore Convention, with its focus on parties arriving at precise legally enforceable solutions, could lead to a reduction in creativity in mediation outcomes?
Hi, Brian. Thank you for this question. Actually, the answer is no, because the Singapore Convention actually does not prescribe an outcome. The Singapore Convention really does one thing and one thing only. It basically says, if you have a settlement agreement in your hand, whatever the settlement agreement itself says, then you can actually take it to a country that is a signatory to the convention and has ratified the convention, and get it enforced in that country. That's all it does. So how you draft that settlement agreement, how you arrive at the terms of the settlement agreement, that still remains entirely up to the parties, entirely up to the mediators. The convention has no impact on it at all. It will equally allow enforcement of an uncreatively drafted settlement agreement, as well as one amazing one, which basically says, I want this party to basically run a full-page advertisement proclaiming how good I am, or whatever, right? It's the convention doesn't deal with the nature of the terms. It basically just concerns itself with, can you enforce this in that country or not? And if you're a signatory country, you've ratified it, then you can present it, and that's all. So I hope that clarifies what the convention does and what it won't do.
Thank you, Junyan. I hope that answers. Yes, it does. So Brian says, thanks a lot. Next up, we actually have a question from Ashani, but Ashani would like to put the question to you herself.
Yeah, sure, please.
Thank you, Jessica. Hi, sir. My question is based on what you spoke about MedArb earlier. I wanted to know, usually in a dispute, are the issues separated for arbitration and mediation? For an example, like the procedure aspect is discussed in arbitration, where the substance is discussed in mediation. Maybe if you could just enlighten us a little bit on that.
Well, okay, so basically what happens at the end of the day is when there's a dispute between parties and there are many issues that need to be resolved, those tend to be what you end up pleading in your arbitration or in your court case. You say that I want this, I want this, I want this, and so on. It would be odd if you went for mediation and didn't cover all of them, because why would you want to leave one issue hanging, when you have the chance to talk about it all? Now, whether you can actually resolve all of them in the mediation or whether they are even something that can be mediated, that's a separate question. But usually parties would go into mediation and try to cover as much as they can, if not the entirety of what they are disputing, so that there's a possibility that you could actually resolve everything at the mediation and you don't actually have to go back to arbitration for that one or two issues that were left unresolved. Then you end up maybe not even having the time and cost savings that you hope to get. So the ideal is parties will try to cover all the issues. And it doesn't always happen. We've had many cases where in a mediation, there are multiple issues that get settled and some issues still are left unresolved. And even in those cases, we would consider that a successful mediation, and the parties very often consider it a successful mediation, because even though it leaves unresolved certain matters, it means that I was going to go to court and I was going to argue over 5 issues, and now I'm only arguing over 2 because we settled on 3. That alone achieves time savings and cost savings, and can sometimes make the case a lot easier to go forward, because you don't have these interlocking issues that actually complicate the story. But now 2 clear disputes, we need the court to rule on this or the arbitrator to make a pronouncement on this. But these 3, we've already talked about it and we've agreed and it's gone away. So I would say that in most cases, parties will try to deal with the totality of the substantive issues, but they don't always succeed within the time frame that you get, or just sometimes it's just too far apart and they have to go back to the arbitration.
Thank you very much, sir.
Welcome.
So next up, we do have another question. It's submitted anonymously. So is it accurate to understand the Singapore Convention on Mediation as just the New York Convention, but for mediation?
I guess that's how people try to describe it, because that makes it the easiest thing to understand for lawyers who are already familiar with the New York Convention. Then you sort of know the purpose of the Singapore Convention is to have that same enforceability across countries. But that's probably where the similarities end, because by definition, a mediation is very different from an arbitration. So, when a mediation takes place, it can take place in any location, it can take place over Zoom, it can take place in many places. There can be no governing law or procedural rules that are surrounding the mediation process, which is very different from an arbitration. For arbitration, there's a seat where it's like the legal venue of the arbitration, and the laws of the country, the arbitration processes of the country apply to the seat of the arbitration. So the New York Convention does mention the seat of it, and it uses that as the reference point of whether the arbitration award can be enforced, because the seat must be in the convention country. The Singapore Convention is different because there is no such concept of a seat in mediation. So it doesn't make any reference of that sort. It doesn't even require you to have mediated in any particular location, as long as the award that you're the mediation settlement agreement you're trying to enforce is being enforced in a country that signed and ratified the convention. That's good enough. That's all the convention says. So yes, it is similar that it's about enforcement, but no, it's not, because mediation is quite a different creature from arbitration. And so a lot of the similarities are not there. And so I think if you needed a shorthand to explain to people what the convention is, you could say it's a New York Convention for Mediation, but be careful that it doesn't then lead to them thinking that all the things that you can find in New York Convention are equally found in the Singapore Convention. It's not. It's quite a different convention entirely.
Thank you, Junyan. Well, I should hope that suffices for the anonymous question. Okay, so we don't have any questions in the chat right now, but for everyone else, please feel free to drop your questions in the chat. If not, you can also unmute yourself to pose the questions directly to Junyan.
I see a gentleman whose name sounds like he might be from the African continent, Mr. Anthony Nwabuike or something like that. Hi, where are you from?
From Nigeria.
Oh, wonderful. I actually had the opportunity to transit in Nigeria. I never actually visited Nigeria. I was on my way to Ghana. So I actually transited in Nigeria.
We are free to come visit Nigeria at any time.
Thank you.
I see we have more faces joining us on video. Can I assume that you have questions for Junyan as well?
Hi, Jessica and Jan. My name is Roar. I'm listening in from Oslo in Norway, and I really enjoyed your short lecture. At the moment, I'm sitting writing an article to our main financial paper regarding the Singapore Convention. And the reason I do that is that the awareness about the convention is not present in Scandinavia and Norway at all. So together with my team that's now participating in the competition, and we also attended the ceremony in August last year, we're trying to raise awareness among the business community, among the lawyers, and among our politicians that this convention is something that's very useful for Norwegian companies that are trading around the world. But I can tell you it's a long way to go because, you know, we don't even know about the convention.
Yes. Yes.
So I just wanted to give that as a comment. So one thing is to go into and understand the convention and how we can use it, but we are even, you know, a further step back there.
Right.
It's not even an awareness.
By the way, can I just say your name is amazing, Raw. I love that.
Thank you.
I totally understand what you're saying because one of the things that we found at the signing of the convention last year was that the European countries were conspicuously absent from the signing. In fact, the EU as a bloc was entirely missing. But there were Europeans at the signing ceremony, mediators who had flown in or were working in Singapore and were interested in the signing ceremony. And I had a chance to speak to a few of them. And they universally expressed their disappointment that their home countries, the governments, was not supportive of this, or maybe not supportive is not the right word, but just not interested. It didn't seem to be something that was worth anyone's time. And I did have opportunity to speak with some of the people who, as you know, I mean, Singapore played a big role in the drafting of the convention. So some of the key players involved, they did share that at the working group discussions, there was a little bit of disagreement by some of the European representatives about the convention as a whole, where I think that there was a sentiment that the Europeans preferred. And again, when I say Europeans, I know it's not universal, but it's just that there are many of them who are represented there who felt strongly that there should not be a convention, but there should be simply model laws that people could adopt in their home countries, some form of harmonization across borders, but not a treaty of that sort where people would sign on to. And I think that was a major difference between a lot of the European representatives at the working group and the rest of the world, in fact, the Americans, the Asians. So it kind of ended up with a situation where once the convention was done, understandably, the response from some of the European countries was quite lukewarm because their representatives might not have gone back and carried a very positive picture of the convention in the first place. And so how would the rest of the government even know? They'll be like, oh, okay, this is my representative there, and he says it's not very important, so why bother? I don't know. I just hope that eventually, increasingly, people will come around to it. One or two countries may just, because I do understand too that the EU has its own constraints, where as a bloc, you've also got to have a certain level of agreement. You've got to go back to Brussels and check with them on this. So you can't just sign things on your own. So these are some of the constraints, but I hope that eventually when one or two countries start to unilaterally sign on to the convention, that creates that question that the rest start asking, say, hey, should we also consider this? Especially, I mean, if you think about it, at the signing ceremony, when was the last time you saw on the first day the US, China, Russia, India all signing this, and you get a representative from Israel and Iran on the same stage for a photo? So I mean, that was quite a momentous event, I thought.
Yeah, I had a pleasure to be there at that moment, and as you mentioned, and this is what I also include in my article, when China and India and United States and China and United States are in a trade war at the same time, and are able to sign this on the same stage, I think it's tremendous. And when you relate that to the New York Convention, and in 58, 6 countries signed it.
Exactly.
And you have 46 signing it on the opening ceremony in Singapore, and that's amazing. So we need to continue to work, and by helping that out, I hope that we could be able to create some awareness, but I think we need to go into the users, the business partners.
That's right.
So they could to be aware of the benefits, how you could both the method of using mediation, but then the ability to enforce it in a completely different manner than they have to do without it. So Thank you so much.
Pleasure. And may I just say that if you need the assistance of the mediation community in Singapore, with whatever you need over there in Norway, I think we'll be happy to reach out and help you. The closest I've been to where you are is I've been to Stockholm, and that's about it.
Okay, so then you're welcome to Oslo.
I will try to get there.
Thank you. We're just approaching the hour, but we do still have time for 1 or 2 more questions, if anyone would like to drop them in the chat. Well, it looks like we don't have any questions. Good job, Junyan, on a clear presentation.
Everyone's just so confused that they just want to log off.
Confused? Why? Have you been making everyone turn around in circles, like your background?
Maybe.
Very TikTok-ish, I should say. Very.
Thank you.
It's all about the loops, Okay, so thank you everyone for joining us today. For those who are not able to join us, the session is going to be recorded and uploaded on YouTube. So it's okay if you came in late and you missed the earlier part of the session. And we will see you all again on Friday for other IMSG events.